Good morning, everyone. A very warm welcome to this webinar that is organized by the legal group in the project, in particular by Mariana, who is the one also organizing this session today. My role at the moment is just to give you a very brief introduction about what we are going to do. Mariana, would you kindly start sharing your screen for this purpose so that we have the slides? We have 1 hour. Great, this looks good. We have 1 hour to go through quite a lot of content. That has to do with the legal rules on data sharing in health-related research projects, like this one here, the Virtual Brain Cloud. And my role is to simply to be, in a way, the housekeeper. So the agenda consists of 5 minutes me speaking boring things, and then 45 minutes about the important parts here, in particular the legal framework for data sharing concepts such as the one in this project. We then have 10 minutes for questions and answers. We would also suggest to keep the questions and answers at the end. The reason for this is that it makes it easier to cut content out or to put content in if that should be needed in a later phase for dissemination purposes. Kindly put your microphone on mute if you don't want to speak, so that we don't have any echo effects. And please feel very welcome to participate as actively as you want. Next slide, Mariana. My background for this, as you certainly know, my background for this is that we have been, as UniV, have been involved in quite some projects in the last 10 years or so, or 15 years. And the main outcome of this is that whenever it comes to any kind of sharing experience in a late stage of the projects, the nasty legal things start to be very boring. It's important to have them regulated at the beginning, and I very much appreciate that we are doing this at this still relatively early stage of the project. Please be advised once again that we record this session, but of course we can also edit the video after this meeting. So if there is any need that we should erase content, that would also be possible, obviously. Thank you very much. The second thing I need to do is to introduce the other speakers. That's a relatively easy task because I have been working with all three of them quite intensely. I will do this in alphabetical order, which therefore leads me to Michael first. Michael Czepik is a research associate at the department, works in health and law related projects for some time now, research interests mainly in data protection law and biotechnology law. He also has some biotechnology background in his educational track record. Emily Johnson, second, is qualified with a law degree of England and Wales and an LLM specializing in technology law. She joined the department in 2018 and currently works in several EU projects, in particular on internet regulation, e-privacy. She is writing her PhD in data protection and the regulation of biometric technologies. And finally, third, Mariana Risotto is a lawyer graduated from the University of Buenos Aires. She joined the department in February 2019, and since then has been involved in quite some projects like this one here. She also has worked as advisor for the private and public sector in Argentina and Austria, including the Ministry of Economic Development of Buenos Aires. Very happy to have all three of you with us. My name is Niklas Forgo. I'm the PI in this project. Mariana, your turn. You need to unmute.
All right,
great.
Yes. So thank you very much, Nicholas, for the introduction, and very welcome from my side and our side, also on the BBC team, legal team. So we will start, I think, first with Emily. So I will hand over the the presentation to her. She will introduce the legal framework applicable for data sharing in these kind of projects. Thank you.
Thank you. Good morning, everyone. So I'm just going to introduce the general legal framework and terms and definitions applicable when it comes to data sharing in general in EU projects and particularly in the Virtual Brain Cloud project. So to start with, the processing of personal data in the EU is regulated by primary and secondary law. An example of the primary law would be the Charter of Fundamental Rights, for example. Secondary law sets out the specific conditions then pursuant to the processing requirements in the primary law. An example of this is the GDPR and national law, which sets out, for example, the GDPR sets out the processing of personal data with regard to natural persons and also the free flow of personal data in the EU. The GDPR has provisions which make up a significant portion of the following discussion. So that will be the focal point of the following slides. But just before that, there are also additional resources which we pointed out which supplement the GDPR and its provisions, such as the guidelines on the concepts of controller and processor and joint controllership, as set out by the European Data Protection Supervisor, the Handbook on Security and Personal Data Processing by ENISA, and also then the recommendation for the protection and use of health-related data, as set out by the UN Special Rapporteur on the Right to Privacy. Next slide, please. So Article 4.1 of the GDPR sets out the definition of personal data as meaning information relating to an identified or identifiable natural person. So that's the data subject. And according to this definition, an identified or identifiable natural person could be anyone who can be identified either directly or indirectly. And this can include, such data can include person's name, obviously, or their face, a number, an email, but it also can include genetic material or anything related to physical, psychological health, or, for example, the economic or cultural social identity of a person. And as we've mentioned, and I believe in deliverable 2.1 of this project, imaging data may also be considered an identifier. When it comes to assessing whether information is identified or identifiable in relation to the data subject, you can consider the following factors, such as the cost and the amount of time required for the identification of a data subject, the available technology at the time of the processing, and then any potential technological developments. We also have Article 4.4, paragraph 15, data concerning health, which means personal data related to the personal mental health of a natural person, including the provision of health services, which reveal information about his or her health. Article 9.1 of the GDPR confirms that any data concerning health constitutes a special category of personal data and shall be prohibited unless it's permitted under Article 9.2. And one example of one way in which the processing of this personal data may be permitted is through the explicit consent of the data subject. So having mentioned some of the key definitions related to controllership structures and data sharing and the processing of personal data in general, we can look at the definitions related to the roles within a data sharing structure. One key example, which I'm probably sure you've all probably heard a number of times, is of the controller. So the data controller means any natural legal person, public authority, agency, or body which alone or jointly with others determines the purposes and means of processing of the personal data. And the role of this entity, or the role of determining the entity who's processing the personal data, is a key contributing factor when it comes to complying with the GDPR and understanding which rules apply to you as an entity. It has been said, for example, by the ICO that understanding your role in relation to the personal data you're processing is crucial in compliance with the GDPR and the fair treatment of the individuals. In establishing whether or not you're a controller, some interesting points can be considered, such as whether or not you've decided the purposes or means of processing, such as the methods that are employed and the ways in which the processing is done. If you decided what personal data is being processed or collected and who it's being collected from. An example of determining the purposes of processing would be the determination of the kind of research you are doing and which people you are doing the research on and the kind of tools you're using to accomplish this. It's also interesting to consider if you have a direct relationship with the data subject, because this can also indicate whether or not you are the controller. But ultimately, as it says in the name, it's a matter of control. So as highlighted, determining the means and purposes of processing is something which should always be considered when establishing your role when it comes to data subject and when it comes to data processing and within the project. Next slide, please. So if it is the case that you as an entity are not determining the purposes and means of processing and the tools which are used, it can also be considered that you may be a processor. So the roles, for example, of a processor means that is a natural or legal person, public authority or agency or body, again, which processes personal data on behalf of the controller. So the processor should not engage with any other processor without specific written consent of the controller, and any processing by the processor should be governed by a contract or legal conditions set out by the union. In establishing whether or not you are a processor, it might also be useful to consider the ways in which you process the activities or the ways in which you perform the processing activities, and whether the ways in which you do this, the methods you employ are directed by a controller or another entity, or the amount or type of personal data is controlled by another entity, i.e. the controller. So one particular data sharing structure could be the controller processor structure, and if or when processing is carried out on behalf of the controller can only process personal data with the specific guarantees to implement appropriate technical measures and organizational measures that it will protect the rights of the data subject. And further, the GDPR also says that any processing by the controller should be done so under a binding contract or any other legal act under union or member state law, which sets out the duration of processing, the nature and purposes of the processing, and the type of personal data and categories of personal data, and then the obligations and rights to the controller. And this would be, for example, this agreement would be one example between the controller and the processor of a controllership structure. Next slide, please. Another example of a controllership structure set out by the GDPR is a joint controllership. And Article 26(1) of the GDPR states that a joint controller or joint controllership is where two or more joint controllers determine the purposes and means of processing, in which case they should be joint controllers. And if this is the case, then the joint controllers will need to be transparent in the manner in which they set out the respective responsibilities to the data subject and in relation to the GDPR. And also the joint controllership, so the joint controllers must also consider their duties to the data subject in data subject rights, in adhering to the data subject rights, such as Article 13 GDPR, when data is being collected from the data subject, or Article 14 GDPR, where it has not been collected from the data subject. And this should be established through a kind of arrangement established by the joint controllers, and it should also designate points of contact for the data subjects in relation to the different types of processing, and it should also reflect the respective roles of the controller and the relationships between each of the controllers, and then vis-a-vis the data subject. And also it's set out by the GDPR that the essence of any such arrangement must be made available to the data subject. So next slide, please. So one thing that we often find in the EU projects is that it's not always clear whether or not a joint controllership has come into force or can be established. And the guidelines from the European Data Protection Supervisor states that a general level of complementary unity of purpose could already trigger a situation of a joint controllership if the purposes and essential elements and means of processing operation are jointly determined. So that expands further somewhat, or helps assist in interpreting the GDPR, but we also have case law, which says that an entity does not need to have access to personal data to be considered a controller. It is simply enough that it determines the means and purposes of processing. So we have that again, and can influence the processing caused by the causing the processing of personal data. And one example of that would be being able to make it start and being able to make it stop. And this can even include receiving anonymous statistics of personal data collected or processed by another entity. So a further point is that the existence of a joint controllership should be established on a case-by-case basis. As we will see further on in this presentation, it may either be an entire consortium of a project, depending, for example, if they jointly determine the means and purposes of the processing again, or it may, as it appears to be in other projects, and maybe in the case here, that it's more suitable that it comprises of smaller joint controllerships or smaller controller processing structures between different cohorts of data. So it entirely depends on a case-by-case basis. But as I've probably mentioned so many times now, it's a matter of who determines the purposes and means of processing and who has control over that. That can determine the controllership structure, whether it's processor controller or a joint controllership. So thank you.
Yeah, hello also from my side. Just very briefly, I will also repeat some of the definitions that Emily set out because they are very important. I will be talking about the contractual options the GDPR provides when it comes to data sharing. And whenever there is sharing of personal data taking place between more than just one person or partner, it should be governed by an arrangement that is preferably in writing. And deciding on the appropriate legal or contractual basis is a decision that should be based, as has been said, on the facts of the data flow and the data structure. And this also explains why we can even have more or different types of agreements within the same projects, for example, when it comes to different cohorts. And as outlined in the first presentation, the initial step to establish which agreement is the right one is to allocate the role of the controller and the role of the processor or any other sub-processors. I would like to outline 3 different agreements: the joint controllership agreement, the controller-processor agreement, and then lastly, the processor and sub-processor agreement. Next slide, please. In the joint controllership agreement, we find that the parties commonly determine or converge on the purpose and essential means of the processing. And we find that mere cooperation itself is not enough. More, they must act in the sense that they cooperate in a way that they together determine, again, the means and purposes. And you find these kind of structures, for example, in a group of companies, but also in research projects as the TVB. The division of the responsibilities must not be equally, so one partner can be responsible for certain rights and the other for others. In general, when they determine the means and purposes together, the European Court of Justice interprets the joint controllership in an extensive way. And the reason for that is clear. They don't want to leave any gaps in the protection of the data subjects. So it says here that they shall, in a transparent manner, determine their roles. And transparency means in this way that the information addressed to the public or the data subjects should be concise, it's easily accessible, easy to understand, and clear and plain language should be used. You can even use visualization if this is appropriate. The information can be provided in an electronic form, for example, via a website. Article 26.2 then says that the agreement must duly reflect the respective actual functions. So again, here it is important to really analyze the case and then see what role each of the controllers involved has. Making this agreement in writing makes therefore sense because it establishes legal certainty. However, the GDPR does not stipulate a specific form here. The essence of the arrangement shall be made available. What is the essence? Basically, this is the clear allocation of the respective duties, especially when it comes to the information requirements controllers have to give to data subjects, and also the responsibilities when it comes to the enforcement of the rights of the data subjects, which includes the procedures and mechanisms, so how the data subjects are able to exercise their rights confronting the controller. Making it available, again, is one option would be electronically via a website. It does not have to be a transfer of a written piece of paper, for example. Next slide, please. So now to the content. As a first step, when we establish that a joint controllership agreement is the right form of contract, we have to define who is responsible for which role in the processing phases, because only then will the agreement fulfill its function of creating exact legal certainty for everybody involved. It must further specify the purpose and means, and who is responsible for what step along the way. It should also cover how the processing is done. I will be talking about the nature, purpose, etc. Later on, but this also has to be established within such an agreement. And as set out by Article 26.1, it should cover the lawfulness of the processing. So who is responsible for obtaining consent, for example, who identifies the legal basis, the information requirements, who provides the necessary information as required by the GDPR, then who is responsible if data subjects exercise their right. This can be allocated. So one partner, for example, is responsible for data portability. Another is responsible for the erasure process. Security measures, as outlined in Article 32. Then the selection of the technical and organizational measures. Implementation of the data protection by design and default principle is especially relevant here, as this is a project that is developing. So who oversees the implementation of said principle in the developing of the project? If there is involvement of subcontractors, who provides the contract for this, and how will the other controllers will be informed? And then what happens if there is a data infringement or a breach? Who notifies, for example, the data subjects? And then also any transfer to third countries. Next slide, please. The next agreement would be the controller-processor agreement. This is to ensure that there is a legally binding and documented manner the processing is taking in this way whenever there is a third party involved. This must be a very precise agreement, so it should cover all the facts that the sharing involves. The purpose is that the processor is bound to the controller, because only then will the controller be able to effectively have influence on the processor. So this is really a legal necessity. We see that, again, here should be governed by a contract. Should be in writing, but can be in an electronic form. The controller has what is called culpa in eligendo. It means that he may only choose people or processors that are, according to recital 81, in possession of expert knowledge, reliable, that they have the resources and implement technical and organizational measures, so that there is no, when you do processing with a processor, is no more risk to the data subject than when you do it yourself. Before we go into the content, if you are a processor then and you go beyond what is within the agreement, and you then decide on the purpose and means of the processing, you are regarded as a controller with all the responsibilities you have. Next slide, please. So regarding the content, you have to define the subject matter of the processing, the duration. In general, you can, it is allowed to have a continuing obligation, so with no formal ending, but there must be an ordinary termination clause or option in this contract. Then the nature concerns modalities. For example, how you process the data would be, one way would be to collect personal data. So this is one form of the nature. The purpose, what's the intention? This should be precise, because this will be very important for the purpose limitation, which is one of the principles of the GDPR. The type of personal data. So for example, is there special categories of data, such as health data? The category of data subjects could be employees or patients, and the rights and obligations of the controller. The agreement must further state that the personal data only be processed on documented instructions. This is not a formal requirement, but the processor has the obligation to document whenever he is asked to process personal data from the controller. Recommended, of course, is in writing. According to recital 39, also the personal data should be processed in a way that confidentiality is observed. So anyone involved in the whole processing activity must be bound either by law or a contract to confidentiality. Again, here is no form, but in the view of evidence, written form is recommended. Then we have again Article 32 with security measures. The GDPR says, for example, encryption or pseudonymization. So this also is relevant for the processor. Limitations on sub-processing, I will come to that in the last slide. Then in the agreement, it also has to establish all the security measures, potential data protection impact assessment, and then also the range and duty and how the processor assists the controller whenever there is any problem or arising within this process. The contract must also provide for arrangements after the processing operation is more or less over, so after the termination. At the choice of the controller, this could be the deletion or returning the data that were processed. And lastly, he has to help and support with information whenever there are audits or inspections. Next slide, please. As the final agreement, we have the processor and subprocessor agreement. Again, all processors must be subject to instructions from the controller. So even if you are using sub-processors, they must be bound to the controller in a way. Whenever you want to exercise this sub-processing, prior approval by the controller must be given. This is to be understood like consent. So this has to be given in writing, not just electronic form. This would be not efficient. So this is really a written physical confirmation. Finally, when you are using subprocessors, again with the consent of the controller, they are bound to the same limitations and obligations as the processor, and this is also done via an agreement, and they have to have the same sufficient guarantees and technical and organizational measures. Next slide. I have now visualized the contracts. The first one is the joint controllership. You see they're more or less cooperating and on equal hierarchy. Together they determine the processing. The next slide. Here we have a controller processor. So we have, for example, the project coordinator, who is the controller, and he determines on the means and purposes. And then we have partner one and any other partners that are processing on behalf of the data controller, the project coordinator here. And as the last option, we would have, again, a data controller and processors and subprocessors that always act on behalf of the data controller. Yes.
Thank you very much, Michael. So on my part, we have already reviewed the relevant concepts from data sharing of the relevant concept for data sharing of the GDPR. And as we have seen, depending specifically on the roles that are attributed to the partners of, for example, a research project like the TVB-Cloud project, we have seen what kind of contractual structures, if needed, needs to be put in place in order to allocate different responsibilities and liabilities too. From the next slides, what I intend to address is a more practical step. What happens and what kind of information do partners need when they are willing and intended to share, of course, certain data sets that either they specifically control or they have either on let's say, on their remit or under a third party availability. So one of the most important, let's say, one of the most important part of data sharing is specifically the planning. So it's recommended that before data sharing, there are certain, let's say, kind of information that you need to collect as a partner if you do have your data set that you are willing to share. In order to, of course, to comply, let's say, with specifically data protection principles. What you can see in the screen is a data flow, or what we will call a data life cycle on data sharing, specifically picturing three phases of data sharing: the pre-phase, the pre-data sharing phase, the data sharing phase per se, and the post-data sharing phase. Each of these phases have different stages, and this is, let's say, also reflecting the information that is needed to be collected by the partners that are going, of course, to be reflecting different principles too. So when speaking, let's say, practically in terms of operation, we start with the data availability in the pre-data sharing phase. Data availability respond or answer to the question, which data set are you intended to share? What is the intention of your data? What are the rights, the right of the data subjects involved? What are, let's say, the data subjects per se involved. Is it personal data? Is it not personal data? According to the concept that Emily already explained. The second one is the data access. So in terms of data access, these questions are attributed specifically which are the legal provisions. And so is the data accessible? Are there any legal provisions that first allow the sharing of this data? Second, on which terms? When this is clarified, the data sharing phase per se is the data transmission, and this is specifically important to know for the partners what kind of security measures are being taken place specifically for the data in transit. So, and specifically attention should be given when there is data concerning health data, as also mentioned by Emily, let's say, intended to be shared. The last phase called post-data sharing is again data access. So once the data is in the recipient's site, so who is going to have authorization for accessing to the data? Are there legal requirements already stated before or stated within the recipient? What kind of measures and limitations are there to access the data, as well as for storage? What kind of storage mechanisms are going to be put in place to store the received data set? The last one, it doesn't mean that specifically this is an option, but data deletion once the, let's say, the purpose of the data sharing is already achieved, what needs to happen with the data that is in the recipient site. Most of this, and that's why we include deletion, is going to be deletion, but this is not the only possibility. I want to focus specifically for the project in the first two, that let's say the pre-data sharing phase. And here I will start with data availability. Again, this replies to all the, let's say, the conditions for data sharing. So setting up all the conditions necessary to be able to share a data set, and what steps we need to take as a partners that are willing to share this data, to consider, of course, I mean, to be, of course, in line with the GDPR principles, which nonetheless, and just to repeat, in case that we don't, in any cases, for example, data minimization, purpose limitation, story limitation, to accountability in terms of security. So first, one note that I want to do is, as the project in principle is a pan-European project, the sharing of the data is going to be in Europe, with the except of one case of the UK. Then we will discuss this perhaps later on the Q&A session. These steps are specific focus on that. There is, in any case, that there is a transfer to third country party to third countries. There is, of course, by the GDPR specific provisions that need to be followed in specifically Article 4450. So coming back to this is the data availability. Here we had the question, which data set and which data set under which intention and what for what, I mean, who is going to be a recipient. Again, just only to remind, there's always a good reason for sharing there has to be, sorry, a good reason to share this data. This could be, of course, research purpose. So the purpose is basic, specifically what data set. So it could be the whole set data set, only one part of it. And of course, whether, I mean, and of course, the key question here, specifically for the applicability of GDPR, if the data set that is intended to be shared is under the definition of personal data. The second, we have already mentioned this, is to secure a legal basis for data sharing. That was specifically the question, whether is there a legal basis for data sharing. We first need to assess the role of the partners, not only of the partner that has the data and is willing to share, but the partners are going to be the recipients of that data set. and also assess the need of DPIA. DPIA is a data protection impact assessment, and it's an assessment that on the risks that can be involved in the processing of personal data. This is an instrument, in certain cases mandatory, but we need to check with the DPO independently, of course, of the data sets that you are willing to share. Something important, and because this has been addressed in other contexts within the project, was whether it's important for the data sharing that the project does not collect new data for the data sharing, and the answer was here that this fact is irrelevant. What is important is to know from where this data comes from, and how, of course, this is accessible to the project, and from there, if there is a possibility to share the data under the legal conditions attached, and of course, if there is an agreement that is needed to be put in place. The second focus that I want to give was regarding the data access. I already mentioned this a couple of slides before. The legal access specifically means or refers to the legal restrictions on conditions on the data originator. Data originator is the one, as I was saying, the one that holds the data sets that are willing to be shared. So many times here, there are two kind of origins of the data set. The one is the direct origin. In this case, the direct origin is, for example, one partner that has conducted a clinical trial and has the data availability on their site, and is willing to share that data with the project. The second one is the indirect origin. Indirect origin is basically when there is a third-party entity that holds the data, for example, UK Biobank, and the partners need to first contract with the third-party entity, and then see whether within the legal, let's say the contractual, of course, terms, or there's any other legal basis that this data can also further share with the project. So we have, once we have all this information collected, this information is specifically needed for one, let's say, two phases that we have identified that will happen in the TVB-Cloud project. The first one is the data sharing for research purpose, of course, during the project. And the second one is post-research phase of the project. So what happened when the sharing of data, when the project ends, and still, of course, the data is shared or basically not. So we focus on the first phase. The second one we will discuss as a second step of the legal team. A summary of these steps and all this information is specifically, as we said, identify the internal data flow. Many times here map out the data origin, as I was saying, that indirect or direct origin, and who is going to be, I would say, the target group or the recipients, better said. Here we developed a questionnaire that is going to be available to the partners as a source of the guidance to collect this information for yourself, and also determining what the role is, what the data set, and what needs to be done as the next step. Legally speaking, of course, you can come to us. The second is to identify the data sets and the data types. So specifically, if there is personal data involved, to establish the legal basis for this data sharing, and if there's any restrictions from this arising out of this legal condition. Also to assess the processing activity. Again, this is purpose, the length, the duration of the data sharing, the possible results of the processing, what is going to happen when the purpose is already overdue, and what are the partners involved, and what are their roles. Again, just linking to what Michael presented was regarding the contractual network or possibilities. Is there a need to establish data sharing agreement, and what do we need to do? Again, also to describe the security measures for the data sharing, specifically when we take into consideration this data sharing phase that I showed in the graphic as data transmission. And let's say an overall summary is that it's always recommended, suggested to have all these points in writing regarding all the decisions that are taken when sharing data. So the questionnaire that I mentioned, I just highlighted some of the questions. This is mainly a repetition, so I'm not going to address them specifically, but this is all the, let's say, the theoretical part that I explained is made and formulated in a more friendly way. So this would be, let's say, all, and what we want actually to address in this data sharing, personal data sharing webinar are three main points that needs to be considered when sharing personal data within the project, specifically when it comes to health-related data. And this is specifically that for GDPR compliant personal data sharing, it requires planning, as I was mentioning before, by identifying the purpose, the data flow, what the roles of the partners are, the legal basis, and redundantly secure sharing. Also, in order to set up the suitable data sharing agreement, if there is, of course, an agreement to be put in place, always we need before to identify what the role of each partner is going to be. And lastly, this agreement should be guided by the requirements that are set out in the GDPR, as kindly explained by Michael today. So this is the end of the content webinar, and we are happy to receive any questions that you may have or may arise during the presentation. Thank you.
Thank you, Mariana.
Thank you very much.
Yeah, Petra, please.
Yeah, I have already one question. Thanks for the great presentation. So my question concerns the lawfulness of processing. We have the Article 6 in GDPR, and there are different possibilities how to make processing of personal data lawful. The data subject has given consent to the processing of his or her personal data for one or more specific purposes. And B, and then comes C and D and E and F, but I'm specifically interested in D. Processing is necessary for the performance of a contract to which the data subject is party, or in order to take steps at the request of the data subject prior to entering the contract. Interestingly, in B, the data subject does not need to provide consent. This is only the case in A. And so the background of the question is that A generates a lot of problems and challenges in sharing research data, because, I read it again, consent to the processing of his or her personal data for one or more specific purposes. And this means usually the specific research purpose has to be defined. And if there is a change, either you make a very loose interpretation and have some creativity, or it's not possible. Actually, you have to recontact the individual, and they have to explicitly provide additional content for another research subject. If you would go to scenario B, you wouldn't need that consent. And the question is whether for research collection of research data with the purpose of sharing them for broad research, would it be possible to have such a contract with an individual, and by this you would not come in the situation that you need specific consent for specific purposes?
Should I reply? Should I try to reply? Okay, so Petra, Nicholas speaking. So first, thank you for the question. Second, the important part of your question is it's absolutely correct that consent is only one possible legal basis for making the processing legally valid. So that's true, and it's an important learning experience. So consent is just one option. However, Article 6 is not the relevant article, unfortunately, because we are dealing with sensitive data. Health data is covered in Article 9, not Article 6. And the current understanding is that if something is sensitive and health data is sensitive, then the requirements of Article 9 need to be met, obviously. And there is no such paragraph B or letter B in Article 9, different from Article 6. The typical case for Article 6, letter B, is a case where you buy something on the internet, for example. So if you buy something on Amazon, then Amazon needs data from you that they need to process in order to conclude or perform the contract. And then they don't need to ask for informed consent in every single case. So the legal case, and that's obviously different from the scenario that you are thinking of. The legal basis for our cases is Article 9, but again, as I said, Article 9, quite similar to Article 6, does not only mention informed consent as an option, making the processing legal, but in particular in Article 9, paragraph 2, and then letter B to, I think it's J, yeah, letter B to J, there are different options mentioned. The probably most important one for research is J, which makes processing legal for research purposes if it's in line with Article 89 and if it's in line with the relevant European and national law. And this is quite exactly what we are trying to achieve in this project, like in the other projects, to find the appropriate legal basis. And in many cases, it's Article 9, paragraph 2, section J, but that needs more and proper analysis. This is, however, and this is the last remark, sorry for giving you a lecture on this. This is, however, not really exactly in the core of the problem that we are dealing in this webinar here. So the core of the problem that we are dealing with in this webinar is not so much to make the processing legal for the research purpose in the institution A, which could be, for example, Charité, but we are trying to make it legal that this data is shared within the project, which is different from making the processing at Charité per se legal. So the assumption of everything that we are doing here at the moment is that it's perfectly legal what's happening at Charité, and that there is a proper legal basis for the processing at Charité for research purposes, but that on top of this, we need to guarantee that the processing is also legal for Fraunhofer or any other research participant in this project. This is the core we are dealing with here.
Okay, thank you very much. This is extremely helpful. Nevertheless, the typical scenario when we share data is that the other institutions, so if Charité has one purpose for processing the data, then Madrid or Genoa may have other research questions. And this generates a principal problem because typically in the consent, we are encouraged by our legal departments at the institutions presently. The definition of the purpose is quite narrow. So this is there's another debate ongoing on broad consent in Germany. I don't know whether it's the same in Austria and other countries. To provide the possibility that patients, for example, in clinical treatments, provide a broad consent so that the data can be in principle used for all types of research. But this is something that is not the case right now. It is not possible right now. It's under debate. It's a long process here in Germany to have such a rule. And I was wondering whether you could comment if, in your view, this is compatible to GDPR, the European law.
So my gut feeling of this is that the German debate is of course different from many other European countries and their approach, because the German approach tends to be stricter than many others. But the problem per se is not only happening in Germany. So the requirements of the informed consent are quite intensely debated everywhere. Personally, my view on this is that informed consent is not, might be a requirement because of ethical reasons and the involvement of ethical committees into the research process. But from a pure data protection point of view, it's not the best legal basis you might think of. I'm very much in favor of legal rules clearly stating what is and what is not going to be done with personal data for medical research purposes. But again, this is treated, unfortunately, very differently in the European countries. Germany, for example, has a much stricter approach here than Austria. Austria has a very, very actively supporting research approach on this in a distinct law. The Forschungsorganisationsgesetz has very, very open rules on this. And we are in Austria actively trying to broaden the way how research can be done without any consent given, and therefore without the problem in how far broad consent is or is not to be on the safe side.
Thank you very much.
Nikolaus, can I add a question? Stefan is speaking. Does it make our life easier of data sharing if we differ between pseudonymized and anonymized data? So there is a rumor that anonymized data makes no problems, and pseudonymized, which gives, of course, not the chance to give any feedback to the doctor or the patient, is a problem. And for the development of our disease models, we don't need any pseudonymized data. Anonymized data is fully okay for us and sufficient.
Yeah, so then the short answer is please use anonymous data. And if you are sure that they're anonymous, don't care about anything we are talking about. You are outside scope of GDPR. So no rules apply, right? At least no data protection rules apply, right?
Okay.
Yeah. Maybe I can comment, because we are here in the context of TVB Cloud, and this is focused on brain imaging data mostly, and derivative of those that can be more sparse, so contain less rich information than the original brain scans. Nevertheless, it's rich enough to, in principle, re-identify people based on this information. And therefore, here in TVB Cloud, for the data we are focusing on, we will not achieve the situation at the larger scale that we can talk about anonymous data. There will be always pseudonymous.
Yeah, very true, Petra, and very important to say that people underestimate how easy it is to re-identify data sets. So very important to see that a lot of things that look anonymous on a first view are not on a second. And if you then end up in the assumption that you're dealing with pseudonymous data, you are fully in scope of GDPR. So it's wise to know this at the beginning.
May I ask one further question? Is there a difference between the storage of data and the processing of data? So are there different regulations?
No, storing is one form of processing. Processing is everything. Processing is everything that you can think of what you can do with data. Everything is processing.
Hi, Nikolaus. Can I ask a question about provisions for consent or reconsent under the different contractual structures that were outlined by Michael? I was wondering whether, depending on obviously the legal basis for processing, so you alluded to Article 6 and Article 9 and the research exemption as well. So say you have a case where data has been collected under the provision of consent, and do the different contractual structures make provisions for reconsenting participants to get their okay to using these data for different purposes? Are there any obligations?
Yes, I mean, this is one of the very important clauses in there, so that the party offering the data needs to to evaluate whether there is any legal basis making it possible to share the data with other parties. And if the only available legal source for this is consent, then the party giving the data needs to analyze in how far the consent covers this transfer. And if it doesn't, then it's up to the party giving the data to take care of this by asking patients to give their reconsent. But I mean, this is one of the many reasons why we are doing this, right? So to know in how far the party transferring the data knows what they are doing.
Mm-hmm. And in the case where, for example, there would be a need to reconsent participants for their accord, are there possibilities to change legal basis? So could you change your initial lawful basis under Article 6 during the process, or is it set from the beginning of the process?
So this is something where the data protection authorities tend to be very reluctant on, because this is something every data controller has as an idea in a given stage, which is if consent isn't sufficient, let's take any of the others. And there are quite strong arguments saying that if you go for consent, stay with consent and don't take any other later.
Yep.
So that is a risky choice. I wouldn't exclude it completely, but it's at least risky.
Mm-hmm. Okay, thank you.
Thank you. Okay, so if there are no questions at the moment, Mariana, with your permission, I'm going to close this meeting. Thank you very much, Petra. We will come in contact with you, asking you what we should do with the video in quite some more detail, if you agree. For today, we are very grateful to all of you for joining us. We are very open to answer all questions you might have, and we want to insist once again that we really need these agreements. So it's not the personal hobby of the crazy lawyers at UniV, but it's a requirement to keep this project on track. At least in our view, right? So, so thank you very much again for joining. And Petra, I don't know whether you want to add something as the final speaker.
Yeah, just let me also thank you, Nikolaus, and the entire Vienna team for this excellent idea to have this webinar and to have it recorded and to make it available to the community. This is so valuable. I think this is really great. I think the content was very helpful, and also the discussion we had afterwards. So I think that will be really a great asset for the community. Thank you very much.
Thank you very much. Have a good day, all of you. Thank you. Take care. Bye.
Take care.
Bye-bye.
Bye.
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 Thank you. Bye-bye.